All right, let's make it happen. Let's do it. Let's do it. Let's do it. Big blessings. Thank you for everybody for taking time out of you guys this beautiful day for tuning in. We about to get the glasses on because we about to go in. So I'm excited. And once again, I'm just grateful above all else for all of you guys that have been tuning in. I'm about to break down some case law study. Drop a billions in the chat box if y'all are familiar with any case law study. I'm not just gonna break down these laws and let you know how one cannot be denied credit. I'm not just here to not just show you guys where to go read, but give you guys other case law studies where people have actually gone through and done exactly what you guys are looking to do. So I'm gonna break down though a lot of things where a lot of people miss, and within this case as well too, I'm gonna break down the same verbiage that was used to help this consumer win in federal court. I'm gonna break down as well too the claims that they were using to help them win as well too. So if you guys are just tuning in, make sure to like this video so that more people can get in tune with these teachings and with this information above all else. With the things and the information that we've been providing to you guys over the past year and a half truly will and can, if you guys apply it, give you guys everything that you guys need to be able to get anything removed from your guys' consumer report. And if you guys take action on all the videos, y'all could actually even get funded from all of our teachings here and build business credit as well too, all for free here on the YouTube. And with that being said as well too, before getting into this, I want to let it be known for the next 3 people that email me, right, that email us, our email is billionairesclub with a V at gmail.com. I'll go ahead and drop it in the description. Billionairesclub at gmail.com, excuse me. And the club is with a V. And so once again, the first 3 people to message me your guys' goals, I'll go ahead and give you guys half off of the mentorship. So rather than $2,500, I'll go ahead and allow you guys to make a one-time payment for $1,250. Now, you guys are not going to find that anywhere else. So let's get to it, man. Let's get to it. So we all came here for one thing, and I'm going to break down one notable case law study within the Equal Credit Opportunity Act. How many of you guys are familiar with the Equal Credit Opportunity Act? So within it, I want you guys all to go to Saint-Jean. I want you all to move, baby girl. I want you all to look into Saint-Jean ETAL versus Emigrant EMI Grant Mortgage Company and Emigrant Bank. In this case, a group of plaintiffs alleged that Emigrant Mortgage Company and Emigrant Bank engaged in discriminatory lending practices by targeting Black and Latino borrowers in the New York City area with predatory mortgage loans. This is happening time and time again. Bank of America got hit with a lawsuit from the CFPB. I believe it was last year with the exact same, situation. The plaintiffs claimed that these practices violated the Equal Credit Opportunity Act, which prohibits creditors from discriminating against applicants on the basis of race, color, religion, national origin, sex, marital status, age, or because an applicant receives income from public assistance program. And that all is within 15 USC Act. There's tons and tons of case law studies of such. Y'all can look up different ones specifically with Bank of America, right? What I was just referring to. There's specific consumers that have actually gone through and taken them to court and actually won in court and got paid a huge settlement as well too. So there's not only deletions that we can get done and we can discharge these debts, or we can get these accounts opened back up if we have been denied. And a lot of times when we are denied, y'all think that that's the end all be all. Well, I'm here to let you guys know that with you being denied and you getting that adverse action letter is actually evidence of damages being done. See, when you guys I broke down this analogy, or even just situation, not even analogy, I broke down the situation as to where many people are familiar with, accident attorneys, and how right away they're telling you guys to go to the chiropractor, to go to the doctors, and to, have you been to the doctors? Have you gone and visited all? Do you have any actual physical evidence of you being hurt from the accident? But that's what they're trying to figure out. Have you got a doctor's note? Do you got a chiropractor? Okay, one, I told you guys on Monday, y'all can go to the doctor's office and y'all can have them write you something for anxiety. You can't tell. A lot of people do this when it comes to medical marijuana and getting their medical marijuana license. They'd say that they got anxiety. Well, nobody can tell you whether you got anxiety or not from these illegal lending practices, from the inaccurate credit reporting, from the denial of your credit. Okay, since you were denied credit, now you can use that against these corporations. On top of that, you get a doctor's note. That's actual damages that are being done, actual damages to your livelihood. So I wanted to put emphasis on that and bring awareness to that, because a lot of you guys are just going out there and throwing out these laws and claims, but not having any physical, actual evidence to back what it is that you guys are stating. So I wanted to break that down very clearly to you guys. Drop a 1 in the chat box and let's get the likes up on this video if that makes sense. We're gonna go ahead and continue reading this case. So the plaintiffs argued that immigrants' lending practices constituted reverse redlining. So this is why we've got truth in lending in the first place as well too, because there's a lot of illegal lending practices that are taking place, and a lot of times they are targeting certain certain niches and certain groups of people, whether that's women, whether that's single families, whether that's religious, certain religions. They're discriminating against and they're targeting specific groups of people time and time again. And that's why within the Equal Credit Opportunity Act, they state that one cannot be denied on the basis of race, color, age, status, marital status, sex, national origin, religion, color, any of that, right? So as we continue to read, we see that. So that's all in truth in lending. So that's why they passed truth in lending. That's why I believe truth in lending, and this is a violation within truth in lending as well too. And so that's double the finance charge in pursuance of 15 USC 1640. See, these are things that you got to know on the back of, you could read them. You can not only read them, you could break them down, what they mean. In 15 USC 1640, it talks about any actual damage, which is what we can get remedy for, or you can get double the finance charge. Well, what's the finance charge? If there's not a finance charge, if we don't know the finance charge, well, what's the damage now? And the damages are, once again, is there anxiety. Maybe you guys, had to pay for a counselor because of your marriage was being separated from all of the financials and the debt that you guys were drowning in. And I've heard of cases of, just like that. A wife looking to leave their husband, a husband looking to leave their wife because of how much they're drowning in debt, or maybe because of how much the wife got their, the family in debt, or, vice versa. I've heard and seen cases of such time and time again. And so what I want you guys to understand is that debt is an illusion, right? Debt is an illusion. Debt is an obligation or an alleged obligation. And so what I want you guys to understand in general as well too is, if we're the ones whom is administering it and creating this credit, how are we then being given debt and making payments on something that we created in the first place? And so that's why one cannot be denied credit. You will lend to many nations, but you will borrow from none. Deuteronomy 15. Right? So we are the lender in every single transaction. And so with that being said, family, we got to know our rights and how to exercise them and understand these subchapters within Title 15, Chapter 41. So today specifically, we're covering the Equal Credit Opportunity Act, and we're going over a case law where one of these consumers went through and actually won in federal court against Immigrant, which is a mortgage lending company. So the plaintiff argued that Immigrants' lending practices constituted reverse redlining, a term used to describe the targeting of minority communities with unfavorable and predatory loan terms. They presented evidence showing that the bank's loans products had disproportionately high interest rates and fees and were marked primarily in minority neighborhoods. Just like the cash loans, the payday, the paydecks, all of that, those are all in those neighborhoods. Specifically, y'all gonna see them in the hood. Y'all gonna see them in a lot of areas where there's a lot of, Mexicans, or a lot of, blacks, or a lot of, people of, you know, people of color is what it is, honestly. And you guys are going to see that time and time again in hood, in lower class communities. So what I want you guys to understand is that they're taking advantage of these consumers with high interest rates, with, what are they saying here? Unfavorable and predatory loan terms. All right, the jury found in favor on the plaintiffs, concluding that immigrants' actions were discriminatory and they did violate the equal credit opportunity. So in their arguments, the plaintiffs emphasized that the equal credit opportunities protections extend to all aspects of credit transactions. So it's not just a denial of credit, but all aspects of a credit transaction, including the terms and conditions offered to borrowers. They highlighted that offering predatory loan terms specifically to minority borrowers is as such a violation of the equal credit opportunity as outright of one being denied credit. So equal credit opportunity 15 U.S.C. 1691 is not just a denial of credit, but it's also the loan terms as well too. And if those are predatory and if those are outrageous in any way, we can also use that Equal Credit Opportunity Act. And so I want you guys all to go look into that case. I want you all to go to pacermonitor.com, pacermonitor.com, and I want you all to go look into that. And with that being said, I want you guys all to start looking into case law studies with Bank of America. Go to the CFPB newsroom, go to the SEC newsroom, go to all of these newsrooms and see what banks are being sued, what banks are being put on notice for their illegal lending practices, for the denial of credit. See, one cannot be denied their God-given right because from the beginning of the transaction, we are the ones whom is creating it. And to verify and back what I'm stating, they would not be doing business with us if we weren't the ones who created it. Right? Think of a currency and a current within a river, an actual river, right? A river bank, right? And that's what a bank is, right? Well, within that river bank, there's a current, and that current is currency, and that currency is an energy, and that energy is us. We are that energy. We are, I always give this analogy as well too, we are the actual battery. Well, all these banks are now, once they get our signature and once they get our social security number, aka our credit card, once they get these, they then become the extension cord from the outlet. But they're not the actual outlet. They're not the true source. They're not the battery. They're not where this is originating from. But they're an extension cord of that battery to where now they're able to go out and extend it. And what they're doing in the process of such, and what I want all of you guys to go look into, is the 10K filing forms. Right? You guys can see within the 10K filing forms. And what I want you all to bring awareness to is look at the verbiage that they're using. Nowhere in the FDCPA does it talk about an account. It doesn't mention or define anything in 1692A, which is the definition section of the FDCPA, about an account. But it does mention debt, right? So in a whole subchapter that's governing the protection of debt, well, if they're coming after you guys for an account, that doesn't have nothing to do with a debt. That's an account that they're collecting on. The debt was transferred to the trust, which is why I want you all to go look into that 10K filing form so you can get information on the trust, look at the EIN, look at the CIK number, look at all the information, get the president of that trust, the administrator of that trust, whomever, get all of that information. And I want you guys to have them verify whether it's the debt that they're attempting to collect or on the account. Because if it's on the account, well, I don't got nothing to do with an account. Nowhere in the FDCPA doesn't mention anything about an account. Further, and with that being said, and why I don't, and to elaborate more on, and let's get the likes up, y'all. Y'all really are being selfish because so many people can get access to this information just from y'all liking this video, man. All y'all gotta do is drop a like. All y'all gotta do is drop a like. If you don't like it, drop something in the comments and be like, yo, Credit Gotti, you are dropping garbage information. Garbage information, bro. Why am I even here, bro? Why am I even tuning in for these 15 minutes? I've learned nothing, absolutely nothing. If y'all learn nothing, I'm all for it. Drop it down below, man. Drop it down below. Drop it down below. All right, from so with that, what's taking place is they're transferring the credit, the debt, to the trust, and then the trust is then selling that to investors as a security. That's how these markets are moving. All these securities, the NASDAQ, the Dow Jones, all of these are all securities that are all being traded within these markets. So now they're trading, with the debt that we've acquired, and let's say it's a $100,000 loan. Well, that $100,000 was now securitized, and now it's being traded on the markets. Now they're able to leverage that to be able to profit even more money. And that's why there's $6.6 trillion every single day within the foreign exchange market, because these currencies that are being traded within these markets are all coming from us. Without us, there would be no money being traded on these markets neither. That's crazy. There would be no value backed by gold. There would be no value backed by the dollar. Come on now, y'all. So what I want y'all to understand is that they're collected on an account and not a debt, because the debt's been sold. They securitized that debt and sold it to investors, and they don't even got nothing to do with it no more. And all they're collecting on is that account. And the reason why they're able to collect on that account is simply because of the agreements and the loan terms that you guys had agreed to. But that doesn't mean that you were not deceived, that you were not misled. And that's why there's verbiage within the FDCPA's congressional findings that there's abundant evidence of the use of abusive, deceptive, and unfair debt collection practices. Damn, this is crazy how this can just come, off the tip of my tongue, off the top of my head, because I've gone through and I've read this time and time again. And I don't want y'all to believe anything that I say. That's not what I'm here for. I want to direct you guys to the information to go read for self, to go look into these 10K filing forms, to go look into 15 USC 1692, to go out and get a doctor's note yourself and send that out to these companies and let them know the anxiety that is brought to you. Let them know, how your marriage has been, affected, and you guys have had to pay X amount for counseling. Let them know that from your car being repossessed, how has that affected your livelihood, etc. Have actual physical evidence, because in the court of law, it's not what you know, but it's what you can prove. So let's get the likes up. I appreciate you all tuning in. I'm gonna give you guys 30 seconds. We'll end this at 19 minutes to ask any questions that one may have. Otherwise, that's all for me today. Go back and watch this replay and take action on today, and go through Pacer Monitor and get familiar with other case law studies of people that are going through exactly what you've been through as well too, because I promise y'all are not the only one. Every single day what took place with you is taking place every single day. Let's get it, y'all. That's why y'all here, to take action on this information, man. One love. Once again, first three to email me at billionaires, C as in cat, L as in love, V as in Victor, B as in boy, at gmail.com. The first three will get half off my mentorship, being able to work with me hands-on. And we've got 2 calls every single week. We just hosted a call last night that was fire. We went over some real estate stuff, some investing stuff, and some credit stuff. So make sure y'all tune in, man. If y'all are not yet, why not? What's holding you guys back? I promise y'all, from where you're at right now to where you guys want to go, how to get there that much quicker, even if it's not with me, what's going to get you guys there is mentorship. The information, the resources, the connections, all come with a great mentor. Let's get it, y'all.